I'm going to answer how patents are granted today. Hi, I'm JD Houvener, and I'm the owner and founder here at Bold Patents Law Firm. And I've been helping inventors for 10 years and gotten almost 500 patents issued as of today. I'm also the author of Bold Ideas, The Inventor's Guide to Patents. So today we're talking about how patents get granted. This is at the very end of a whole host of steps that takes to research, apply for, go back and forth with the examiner, and finally get to the finish line. I do want to focus on just this step, but I can't talk about the finish line without talking about everything that happened leading up to it. So let's talk about the big milestones and then talk about the actual process that the USPTO takes to actually do the granting process. So to get a patent granted, to go through and finish the race, you have to start, right, by putting on your shoes or identifying that you have an invention. That's the first step. Do you have just an idea or just a quick thought while you're driving? Or have you actually really worked something out and planned it, and actually written it down, have it in your mind, and you can explain it? Now you've got an invention. The next step would be speaking with a patent attorney to decide, is this something that's novel? Is it non-obvious? Does it have utility and merit enough to worth filing, to make it worth your effort to pay for, go through the process of getting a patent on it? That's the giant barrier most of our clients speak with us about initially. That's step 2. Step 3 is applying for and working with the patent office examiner to get your patent granted. Now, those big first 3 steps, the research, the invention, and the applying for, that could take up to 2 to 3 or more years. So this is a long journey. This is not a sprint. You got to make sure it's in your plan, in your business plan, I should say. And part of that effort to get there, can take a long time. It takes a lot of money and time and effort. So understand it. When you get to the finish line, here is the process for the patent office. You've worked with the examiner, likely with your attorney, overcoming rejections, overcoming objections, maybe 2, 3, 4 times. And you're finally at the point where the examiner says, I'm going to allow this set of claims. That's the notice of allowance. At that point, they're saying, we're going to give you a patent. Congratulations. Although they don't say it quite so nicely. And your job then is to say, okay, I agree to all of these terms. Let's get this issued. One of the most important things at this stage is to not just say, okay, it all looks good. Here's my issue fee, and let the patent issue. Is to do a timeout and to look back and say, did we have to change any of our claims? Did we have to give up any ground? Or are there other innovations, other sort of twists and turns or variations of my invention that I've had while this patent has been progressing, pending? Usually the answer is yes. And you don't want to leave any of that on the table. Meaning if you get a patent issued and without filing what's called a child patent or a continuation in part, you've left a lot of rights on the table. And instead of developing what's called a patent portfolio or a family around your invention, you come away with just one patent on your invention, which certainly is better than nothing, but it can be very limiting in terms of your ability to enforce it against an infringer that's trying their best to design around your product, around your solution. So work with a patent attorney. Maybe you're somewhere in the middle. Maybe you've got an office action or even a notice of allowance. Do not just pay that fee to get your patent granted. I know it's tempting at the end of the race to do that, but please go back, work with an attorney and see, did you leave anything on the table? Can we develop your portfolio further and benefit from that early priority date to file a continuation on a child patent? All right, everybody, thank you for the chat this morning. I'm JD Houvener with Bold Patents. Go big, go bold.